Hello everyone, welcome to USA State. If you or someone you love is applying for a green card, there is a new rule coming that could get your application denied, and almost nobody is talking about it clearly yet. Starting September 18th, 2026, immigration officers in the United States will be allowed to look at almost any government benefit you have used when they decide if you get a green card. That means food stamps, Medicaid, housing help, and other programs could now count against you, even if you thought they were completely safe to use. Stick with me for the next few minutes because I am going to break this down in plain, simple English so you understand exactly what changed and what it means for your future. Before we go further, if this channel helps you understand immigration news like this, do me a quick favor and hit that like button right now. It really helps this video reach more people who need it. And if you have not subscribed yet, tap that subscribe button and turn on notifications because we cover green card and visa updates like this every single week. Okay? Let's get into it, because this story actually starts many years ago, long before most of us were even thinking about green cards. The idea of a public charge test is not new. It has been part of American immigration law for more than 100 years. In simple words, a public charge test checks whether the government believes you will depend mainly on public assistance instead of supporting yourself. If an officer decides you are likely to become a public charge, they can deny your green card, your visa, or even your entry into the country. For a long time, this test was narrow and predictable. Officers mostly looked at cash assistance programs and long-term care paid for by the government. Things like food stamps, Medicaid, and housing vouchers were generally left out of the picture, so families felt safe using them without fear. That changed once before, back in 2019, when the first Trump administration expanded the public charge rule to include many more benefits. That earlier version caused a lot of panic, and immigrant families across the country pulled their kids out of programs like Medicaid, even ones they fully qualified for. Later, in 2022, the rule was rolled back under the Biden administration, and things went back to the narrower, safer version most people were used to. For the past few years, that 2022 rule has been the standard, and it gave families a clear line of what counted and what did not. But on July 16, 2026, the Department of Homeland Security finalized a brand new rule, officially rescinding that 2022 version completely. This new rule was published shortly after, and it takes full legal effect on September 18, 2026, which is coming up fast. Here is the part that really matters. This new rule does not give a clear list of programs that count. Instead, it gives officers much wider discretion. That word, discretion, is key, because it basically means individual immigration officers get to decide case by case what counts against you. Under the old 2022 rule, only cash assistance for income and long-term institutional care at government expense really mattered. Under this new rule, officers can now weigh things like food assistance, Medicaid, housing vouchers, and other means-tested programs based on the whole picture. The government calls this a totality of the circumstances approach, meaning no single factor decides your case, but many factors get added together. That includes your age, your health, your family situation, your finances, your education, your skills, and now, more heavily, your use of public benefits. There is something else that is raising a lot of concern, and it involves your family members, not just you. Some legal experts believe the new rule opens the door for officers to consider benefits used by your relatives, including your own children, when deciding your case. For example, if your child, who is a U.S. citizen, receives Medicaid or CHIP health coverage, that could potentially be factored into your green card decision. Millions of citizen children currently rely on programs like these, so this detail alone is making a lot of families nervous right now. Now, I want to pause here for a second because I know some of you are already feeling worried, and that is completely understandable. But here is something important. Receiving a public benefit does not automatically mean your green card gets denied. That is not how this works. USCIS has said clearly that no single factor, including benefit use, will automatically decide the outcome of your case. Officers are required to look at your entire situation, your work history, your income, your health, your education, and your future stability, together. So if you are working full-time, supporting your family, and only using a benefit as extra help, that alone should not sink your application. However, the risk is that it now becomes one more thing sitting against you in the total picture, especially if other parts of your case are weaker. Let's talk about who this actually applies to, because public charge does not touch every single immigrant in the United States. If you are already a U.S. citizen, this rule does not apply to you at all, so there is nothing to worry about there. If you already have a green card and you are simply renewing it or applying to become a citizen, you are generally not affected either. The main group affected are people applying for a family-based green card and certain people applying through employment-based categories. People with refugee status, asylum status, T visas, U visas, or special immigrant juvenile status are usually exempt from this test as well. That said, some of these exemptions can get complicated, especially if someone later applies for a different kind of green card down the road. Now here is a date you really need to remember, September 18th, 2026, because it decides which rule applies to your case. If your green card application, specifically Form Y-485, is filed or postmarked before that date, the older, narrower 2022 rule still applies to you. If it is filed on or after September 18th, the new, broader rule applies, and officers get that wider discretion we talked about earlier. This is why so many immigration attorneys are telling clients right now, do not rush, but also do not wait too long if your case is ready. Filing before the deadline could genuinely change how your case gets reviewed, so timing has become one of the most important decisions families are making. Let's slow down and imagine a real situation, because numbers and rules only mean so much until you see how they play out in real life. Picture a father who works full-time. His job covers most of the family's bills, groceries, and rent, month after month. To help stretch things further, his family also receives food stamps to make sure there is always enough food on the table for the kids. Under the rule before September 18th, this family is generally considered safe because the job is the main source of support, and food stamps are just extra help. But under the new rule taking effect this September, an officer could now count those food stamps as part of the decision, even though the father works and pays most of his own way. That is the real shift here. It is not just about adding new programs to a list. It is about how much weight even small benefit use can carry now. This is exactly why health experts and policy researchers are worried about something called a chilling effect. A chilling effect means people become so afraid of the rule that they stop using benefits they are legally entitled to, even when it would not actually hurt their case. We actually saw this happen before. Back during the 2019 version of this rule, families pulled their children out of programs like Medicaid out of pure fear. Researchers estimate that this new rule could push more than 1 million people to leave programs like Medicaid, CHIP, food assistance, and other support systems. Some independent analyses suggest the real number could be even higher, possibly reaching several million people once you include entire households. Health experts warn this could lead to more emergency room visits, higher uncompensated care costs, and worse health outcomes for children, including U.S. citizen children. Immigration officials, on the other hand, argue this rule simply restores a long-standing principle that immigrants coming to this country should be able to support themselves. They say government benefits should not become an incentive for immigration, and that officers deserve the discretion to properly evaluate self-sufficiency. Whichever side you agree with, one thing is clear: this policy touches real families making real decisions about their health and their future every single day. Now let's talk about something practical, because I know a lot of you watching are wondering, what should I actually do with this information? First, do not panic and immediately cancel every benefit you are using, because that decision alone could hurt your family's health without even helping your case. Eligibility for a benefit and the immigration consequences of using it are two completely separate legal questions, so treat them separately too. Second, if you are close to filing your green card application, talk to a qualified immigration attorney about your specific timeline and situation right away. An attorney can look at your case, your income, your family, and your benefit history and tell you what actually applies to you personally. Third, remember that your affidavit of support, Form I-864, still plays a major role in these decisions, especially for family-based and certain employment-based cases. Officers will also look at whether your sponsor is realistically able and willing to financially support you, so that document needs to be strong and accurate. Fourth, know that there is something called a public charge bond using Form Y-945, which in some cases can allow someone to move forward even after a public charge concern. This bond process shows that even under a stricter rule, there are still paths forward for people who prepare properly and get the right legal guidance. Let's look at another example, because seeing two different situations side by side really helps this make sense. Imagine a young mother who recently got a work permit. She is studying part-time while raising two kids, and her husband works a steady job. During a rough winter, the family briefly used a housing assistance program to avoid falling behind on rent while medical bills piled up unexpectedly. Under the old 2022 rule, this kind of short-term, situational help usually did not raise red flags because it was not the family's main source of survival. Under the new rule starting this September, an officer reviewing her green card case could now factor that housing assistance into the total picture, even though it was temporary. This does not automatically mean denial, but it does mean her attorney will likely need to show strong evidence of stability, income, and future self-sufficiency. That could include steady pay stubs, a clear budget, family support letters, or proof that the hardship was truly temporary and already resolved. This is exactly why documentation matters so much more under this new system, because officers are weighing your whole story, not just one line item. The more clearly you can show stability, work history, and a solid support system, the stronger your case becomes, even if you have used benefits in the past. I also want to be honest with you. Legal groups across the country are already preparing lawsuits challenging this rescinded rule, so more changes could still come. Until courts weigh in, this new guidance remains the law of the land starting September 18th, so families need to plan around the rule as it stands today. If you found this breakdown helpful, drop a comment below and let me know which part surprised you the most. I read every single comment. Also, if you know someone applying for a green card right now, please share this video with them. This information could genuinely change how they plan their next steps. To quickly recap everything we covered, the public charge test itself is not new. But starting September 18, 2026, officers get much wider discretion over which benefits count. The 2022 rule, which protected most non-cash benefits, is being replaced by a broader totality of the circumstances approach that weighs almost everything together. Receiving a benefit alone will not automatically deny your case, but it becomes one more factor sitting on the scale alongside your income, health, and family situation. The filing date of your application decides which version of the rule applies, so September 18th, 2026 is the line that separates the old rules from the new ones. Certain groups, including U.S. citizens, current green card holders renewing status, refugees, and asylees, remain largely protected from this specific test. And most importantly, talking to a real immigration attorney before making any big decisions about benefits or filing dates is the smartest move any family can make right now. This is a fast-moving story, and rules like this can shift again through court challenges, so make sure you are subscribed so you never miss an update. Thank you so much for watching all the way to the end. That genuinely means a lot, and it tells me you care about getting the real, accurate story. If this video helped you understand what is happening, smash that like button, drop your thoughts in the comments, and share it with someone who needs to see it. I will see you in the next video, where we will keep breaking down exactly what these immigration changes mean for real families like yours.